with questions during your presentation, we can do that. Otherwise, we can wait until you finish. You're fine with that? Okay.
Yeah.
So please go ahead. Thank you so much again. Sorry for this inconvenience, but let's get started.
Okay, we just keep an eye on the clock. Hush me forward, delay me, whatever. Okay, I'm used to interrogations.
Great.
Anyway, so thanks a lot for having me. This is the first time I'm in Uruguay or South America, for that matter. And so this is a paper, and I think we met Carlos online through the crime seminar where he was presenting his work on the adversarial procedure in Uruguay, and again we got connected. And here is a paper on something related, but in a Central European version. So this is about a simplified criminal procedure, and in particular, it's evaluating a reform. So to frame it into a broader field, right? There's the economics of crime is diverse, and one of the subtopics is the criminal procedure, where people study things like incentives of the police, prosecutors, and judges, and the effects of procedural rules on case outcomes. Now, there's a lot of literature is focused on plea bargaining, which is kind of maybe too specific American institution, or on the productivity of prosecutors and judges. And we have a little bit to say to each and every of these subtopics. Now, why what's the behind this paper is the basic economic idea that enforcement resources are indeed limited, and that leads to delays or insufficient deterrence or errors. And when the governments can respond in two ways. One is to simply pour in more resources, to hire more judges, more prosecutors, or to do something with the procedure, to introduce some kind of simpler procedure that doesn't need as many resources to take the offender all the way through to the conviction. And they kind of all share all of these, the penal order in or the simplified or accelerated proceedings or plea bargaining, they have a lot in common, that they should be much faster. They lead to a conviction with a near certainty, or actually defined as simple as convicting a defendant. And they little bit, skim on the procedural rights of the defendant compared to the standard, full-fledged trial. In Europe, these procedures have become quite popular, especially in the late 90s and throughout the early 2000s. They were introduced one way or another in many countries. This is not a complete list. This is just illustrative that some countries introduce penal order, these kind of accelerated or simplified proceedings, which I will talk about. Some introduce the American style plea bargaining. Institutional details vary, but clearly there was a wave of these reforms in Europe some 15 to 20 years ago. Well, the literature, however, there are gaps in it. So there's one stream of literature that our paper speaks to, is to the effects of more staffing on court output, which I would say the consensus is more or less that it's largely ineffective, although there are exceptions. Then there is a huge law and economics literature on plea bargaining, purely US focused, which mostly describes the internal mechanism inside the plea bargaining, such as studying the outcomes and of these cases as a function of various procedural details. There is little known about the effects of plea bargaining as such, that is, let's say, the equilibrium effects of introducing that procedure. There is one Italian paper that tries to do that, but the conclusion is that it was implemented largely on books, but not in reality, and therefore there isn't much to evaluate in Italy. And then when it comes to papers on others of these reforms, well, so there is Carlos with the one on the Uruguay reform on evaluating the switch from the inquisitorial to adversarial. And there is, indeed, to our best knowledge, there's no evidence of the causal effects of the penal order or the simplified proceedings, that is, all of these various simplified procedures that were introduced in Europe. And that's where our paper fills the void. So the general question we are asking is, what are the equilibrium effects of a simplified alternative criminal procedure? And namely, what we're doing is we look at a 2002 criminal procedure reform in our country, Czech Republic, which is basically, three things. It really simplified the procedure, but it only covered some very simple, less serious crimes. And you can think of the simple crimes as, petty theft, where an offender was caught on the spot, some minor assaults when there was an injury, but then it's no problem to catch the offender, the evidence is clear, and a lot of these driving offenses, such as, drunk driving. And then the way we evaluate that is we exploit the fact that there was a large variation in the actual adoption between districts. And I'll try to convince you that that's good enough, as good as random, to evaluate the causal effect. We look at two outcomes, the case durations, and then the probability of turning the arrest into further charges, that is the prosecutor bringing the defendant to court, and then the ultimate conviction. So going the wrong way. So a bit of theoretical framing. There's one theoretical framework is the seminal paper by Landis on studying the optimal prosecutor behavior, where the prosecutor is sort of an entrepreneur that is trying to simply maximize the sentences imposed on the defendants, but he has limited resources that has to allocate between different cases. And that derives some optimal allocation of effort across cases. And then if we kind of take the logic of the model and see what happens if a plea bargaining would be introduced into a scheme in a system that has no plea bargaining, that the model has an absolutely unambiguous prediction, the probability of charges should go up. The prosecutor would simply put more cases, either to plea bargaining or to trial, and then at the end, more people would be convicted. Okay. We have a separate paper that which is different in its focus, because it's looking at a more social objective. Right? The objective in our model is a benevolent, some kind of adjudicator, an ideal judge, let's say, who cares about the cost of errors, that is either of wrongful acquittals or of wrongful conviction, still has resource constraint to process these cases. These cases vary. Some cases offer strong evidence, some offer very weak evidence at the time of arrest. And then the adjudicator has three options. She can drop the case. She can push the case to trial, which is rather expensive, but then leads to a verdict with a high precision. Or she can kind of adjudicate that case through an alternative procedure, which means based on the existing evidence, she can simply convict the guy without trial on the spot. Right? So there is a trade-off, right? Putting the case to trial leads to more precise verdict, but it's expensive. So we kind of derive that there is an optimal cutoff where two cutoffs, the weakest cases are dropped, no cases of sufficiently strong evidence are put to trial, and the cases with the strongest evidence are actually convicted on the spot through this alternative procedure. Right? So that model is trying to really kind of encompass the economic gist of all of these alternative procedures. And then when we look at the testable predictions, what happens if you have only trial, or you can only have a trial, or you can only drop a case, and suddenly you do a systemic reform in which you introduce the option of this alternative procedure. Well, so it buys you the option to resolve some cases more cheaply. So then, the strongest cases are convicted on the spot. That allows more cases to be put on trial, more cases to be prosecuted overall. But it also means that this adjudicator actually prosecutes, on average, weaker cases. Mm-hmm. And then there are some errors that are being made through putting some cases through this alternative procedure. Also, the model has maybe surprising prediction that once you do that, more resources should be shifted to the petty cases, which is not quite intuitive. So we have some testable predictions that we'll go after in our empirical work. Then if you introduce that, type of European reform, that is alternative procedure, focusing on the petty case only, but eligible only on the petty cases, this generates a direct effect. And by the direct effect, mean the effect on those eligible cases, on those petty crimes. The probability of charges should go up. That is, these cases will actually be handled towards, some final verdict instead of being dropped. And the probability of conviction empirically may go up or down. On one hand, there's more resources to be invested into these cases, but on the other hand, there are indeed weaker cases are being actually prosecuted. There should be also spillover effects, right? Where again, because there's more cases are actually being prosecuted, the probability of charges goes up. The conviction could actually go down because it's the weaker ineligible cases that go to trial. And for sure, the spillover effect should be smaller than the direct effects. Okay. And the same holds for the case durations. Okay, so we somewhat differ with the canonical Landes model, and then we will see how it plays out empirically. So now institutional background. So and the Czech criminal justice system is a pretty, say, typical continental criminal system, in the sense that it's based on the inquisitorial procedure, for one thing. And it's been traditionally truly heavily relying on trial. So definitely what I say now is describes the backbone of the procedure both before and after the reform. Once a police identifies a suspect, they kind of assess the early evidence and they initiate the prosecution, that is, the person is accused. At that moment, the pre-trial phase begins, where the prosecutor has to kind of approve the prosecution. He would give some instruction to the police as to what kind of evidence to collect and how to kind of structure the legal arguments, for example. And then it's the prosecutor who makes the ultimate decision to charge the defendant at court. Okay, so submits the indictment or charges, as I would say. And then at the end, all cases are adjudicated by the court. So there's no plea bargaining or anything. And then, as both mentioning, indeed, if that gets to court, the procedure is inquisitorial, and also it's worth thinking that there is not much scope for charge bargaining, for example, right? Once kind of a person is prosecuted under certain charges, the charges stick, or it cannot be bargained away to reclassify the offense into, say, another different, legal charge. Now, what's important is the context when the reform was implemented was that there was a single procedure applicable to everything. Now, from a drunk driving to complicated murder or a complicated financial crime. So it's been very formalistic, and it was strongly giving pretty strong procedural rights to the witnesses, always having the attorney, always being able to go through the files, always giving comments or objections against what's on the file. And then also there was a lot of repetition. Essentially, the police would say if there was a witness, the police would investigate him, would interrogate him once during the early collection of evidence. Then once the pre-trial phase is approved by the prosecutor, the witness would be summoned again to a more formal evidence testimony, and then would be invited to trial to testify with the full legal force. At trial, there's preliminary hearing, and definitely all the evidence is assessed and eventually evaluated at trial. And then the deadlines are basically no deadlines for practical purposes. Now, so there was a clear consensus that this is overbearing in terms of the procedural difficulty for these petty crimes, so that essentially all these guys have to go through all that paperwork and essentially play the same game in terms of presenting the evidence as if, for a drunk driver as for a murderer. Okay, even though everybody knows from the beginning that the evidence is absolutely clear. So they introduced a fast track procedure, which kind of falls into these that's our translation. It's one of these accelerated or simplified proceedings, which does less paperwork. So there's simply fewer pages to type by the prosecutor or by the judge when they making a decision. Especially, they don't really have to write complicated legal justification. They simply can write on essentially 1 or 2 pages. This is what happened. This is the supporting evidence. The defendant is accused of committing, crime under section number 205 of the criminal code, and that's it. There's no pre-trial phase. Basically, the police collects the evidence, and if the case goes through its fast track, that's being already taken as evidence, and there is no second interrogation. And then before trial, there's never a preliminary hearing, so there's typically only 1 session. And there is something that could be called like a plea bargaining on the evidence. That is, some pieces of evidence, say the alcohol test in a drunk driving, or the fact that the person was driving without a driving license, or that he was actually caught red-handed stealing something in a supermarket. That's declared by everybody as indisputable, and then the judge never evaluates that. Okay, it's taken at face value. And there are strict deadlines such that they're pretty short, and missing those deadlines actually is consequential, such that under certain circumstances, the case may then revert back to this conventional procedure. So then, the prosecutor does have an incentive to actually be on time, so to speak. Okay. So it's important that for the case to go through the fast track procedure, it has to satisfy some criteria. So an eligible case is such that the maximum statutory sentence does not exceed 3 years. So there's essentially defined a certain, pettiness or less serious crimes. The suspect has to be identified while committing the crime or immediately after, which makes it exactly very applicable to drunk driving or other driving offenses, or these, small, less serious assaults and these, petty property crimes, or very primitive cases of say, fraud or embezzlement. Or then there's another, the evidence has to be clear enough to allow bringing the suspect to trial within 2 weeks, such that, it's any time where the evidence does not require substantial investigative or say, information gathering effort on the part of the policeman. Now, the law stipulates that the cases should be prosecuted through this fast track. In reality, they have the discretion. And the first decision is made by the police investigating the offense, but then the prosecutor may overturn the decision. And typically, they simply discuss it informally and reach a conclusion, whether they go through the fast track or through the conventional. And then the courts have to stick with the procedure. So the court procedure depends on whether it was submitted under the fast track or the full trial or the standard procedure. And then if that happens, the court simply has to continue with the fast track.
Question. May I ask a question, Libor?
Sure.
So one short question. What happens between the moment the individual is identified and the trial? So you say that there is a period of 2 weeks at most?
Yeah.
And so suppose that someone is caught, I don't know, doing relatively petty theft. What happened to him? He goes home and waits?
Well, he's arrested on the spot. He would be brought to the police station. They would type up, they would interrogate him on that again, and he would give, say some kind of private testimony or explanation. They would definitely, accuse him of that crime, which is a formal step. Advise him of his rights and so on. And then this is a petty crime, so he would be released to go home. And then at that point, the policeman would kind of finish the paperwork to make it a complete file with all the supporting extra legalese, and then would ask the prosecutor to actually start the official prosecution, which is kind of a stronger status than just being accused. And then the prosecutor in that case would probably say, okay, this is an obvious fast track case, and that's it. Okay. And then depending on whether the offender would already admit to the crime, or whether, say, there will be a witness that would be summoned, they would summon that witness in the meantime. And if it's not complicated, and if they can really be done in 2 weeks, then the prosecutor would then, in some 2 weeks, should simply submit the case to the court.
So just a short question. Sorry for asking again.
Sure.
So basically, during that time window, the individual waits until the trial, and then the trial, if he is found guilty, he goes to prison, for instance. I don't know. We don't know. But is there any difference with respect to the previous system, the longer track?
Yeah, well, so there would be, say, the witness would have to basically come 3 times. That's an important one. That indeed they will be initially investigated by the police, and then they would be summoned again during that pretrial phase to bring more serious testimony, possibly with an attorney and so on. And then the other aspect is that at any point in time, that evidence could be disputed at any point, could any time be disputed, and the witness would be in a much easier position to be invited to testify again at that moment to change the statement.
Because my question is mostly related to the fact that if there is anything that changes in this reform, incapacitation. So maybe it produces a faster impact, and then you have people incapacitated faster because they cannot commit more crime, because you have a faster sentence, and then as a result, they are behind bars? Or maybe
the prison is rarely used in these cases where the maximum punishment is 3 years, okay? And the Czech system is very weird in this sense that people get usually a suspended sentence 4 times in a row, and then they go to prison for 5 years, so there's a complete on and off, very extreme. But then if they go to prison for 5 years, that wouldn't be under this fast track. So.
Perfect. So incapacitation is not a relevant dimension here.
It's not a major factor here.
It's more deterrence.
Yeah.
Okay, thank you.
Okay. So as for the data, we have full universe of criminal cases in the country for over many years. So what we use here is we have actually 2 data sets that turned out not to be really possible to merge or not with sufficient quality. So we use them as separate. So there's every data set on what the prosecutors are doing. So every time when this offender is accused until the final decision by the prosecutor, and this covers all cases started during this 10-year period. And again, then we have a data set covering what the courts are doing. So every criminal court case filed with the courts over that period. So in total, we work with 1.1 million cases. We work only with cases that start with the district courts. So some super serious crimes like murder start with the regional and higher level courts, so we don't use those. What we know is a lot of the legal detail that is in each section, each charge defined by the section of the legal code. Some offender and case characteristics, such as say the number of prior convictions, details, whether say a victim was female or there was a traffic-related offense. And we know quite a bit about the procedure, namely like when each kind of legal step was being made, like the offender was accused, and the charges were filed, what was the particular outcome that the prosecutor or the court chose. So what we are interested in is the effect on these outcomes, that is the duration from actual offense to the final charges, right? So that's and then to the moment when the prosecutor brings the case to the court, then whether the outcome was the actual charges, so that's the most interesting, most serious result for the offender. At the court case, again, we look at from the moment when the case was filed to the final adjudication. So say the trial itself may be pretty fast, but then the case may still sit on the desk for 2 months before the court even looks at it, okay? And then whether the final decision, including possible appeal, was conviction. Yeah. Okay, so the country is divided into 86 judicial districts. So the district, you have an idea, is an average population of some 110,000 people. So these are pretty small. There's usually like a district capital city, which is anything between 10 to 100,000 people. We aggregate these data to 11 broader offense categories because we do expect, and as you'll see, we were right to expect that the effects will be largely heterogeneous by the offense types. We then need to define which cases are at least potentially eligible for this fast track. Okay, so the way to do it, there's a clear criteria that there has to be the statutory sentence cannot exceed 3 years. So we code the criminal code, we match the maximum sentence into each case, into each charge. We pick up the maximum charge, the most severe charge, and then that way we classify a case as potentially eligible. Just to make sure, if a case is potentially eligible, it still can mean that it is prosecuted by the conventional procedure. Either it does not meet the evidence criteria, it's still a more complicated case, or it just takes more paperwork. And or simply, the prosecutor chose not to use the fast track. And in these cases, with more serious cases with a longer statutory sentence, these are ineligible. Okay. So what we go after is these two things: is the direct effects. That is the effect of prosecuting a particular case via the fast track. So the effect on that particular case, or that is on those cases that were actually prosecuted through the fast track. And then we're interested in the spillover effect, that is the effect on all other cases. Namely, that's kind of a function of the overall usage of the fast track in a district, right? The idea being, if say a given district prosecutes only 5% of cases through the fast track, there wouldn't be much of a spillover. If they do it for half of the cases, we could expect some, some broader spillovers. Okay, a bit of the empirical strategy and the identification. So ideally, we would like to conduct an experiment, a grand field experiment in which we would randomly assign districts. That's saying, you around 10% and you around 90% of cases for the fast track. And then these cases would be also assigned at random. Okay, now that would be a perfect, right? Well, that did not exactly happen. So, but anyway, in that case, this makes a good, I think this is good to explain what we would like to do, right? We would then estimate a simple regression in which on an outcome of a case is a function of the fast track status of a case, which is perfectly random. We would be perfectly random. And then the share of these fast track cases in that district as kind of a measure of the resources that are released by this simple procedure. Okay? So this will be the ideal setup. Well, we have instead a quasi-natural experiment where the complication is that, of course, this assignment is not random. It's clearly non-random, right? The easy cases, the simplest cases are those that go through the fast track. And we have a lot of information, but still we expect there will be unobservables. Right? So what we do then is we use an IV by instrumenting the fast track status of an individual case with the share of the fast track cases in a district. So that is identifying the effect on a single case through the fact that the overall usage of that fast track varies across districts. Now, we'll show you that the actual adoption of that fast track really varies a lot. And especially we'll try to convince you that this is random or as good as random for all practical purposes, and therefore it constitutes a valid instrument. Okay, so here is the variation. So throughout the presentation, I said we have 11 crime categories. Just to make the tables legible, I reduce it to the 5 most important ones, most interesting ones. Okay, so these first 3 are those where fast track was used a lot. So thefts, for example, in the first year of the reform, on average, 27% of thefts were adjudicated through the fast track. But here, this is the percentile in terms of the district. So the the fifth, there were 5% of the districts where it was only 8% or less, and there were 5% of districts where it was 49% or more. Right? And then, over time, 6 years later, the mean has increased, but then the variation quite persists. And this is the base for our identification strategy, right? That there is indeed variation across districts in how that is used, right? And it's particularly striking with these driving offenses because, like, almost all of these are either the person was caught driving without a license or the person was driving drunk. There's no substantial differences into doing this, some in the west of the country than in the east of the country, right? This is just, drunk driver. So still, there were reasons why they didn't use the procedures in some districts and used it in some others.
I was about to ask you about
Sure.
that distinction, because you can have the exact offense committed in two districts,
Mm-hmm.
and in one case you are using the fast track, in the other case you are not.
Yeah.
Could you explain a little bit more why we can have such a difference?
Okay, well, so I have a slide. Okay, I'll skip to a slide.
We can wait.
Like 5 slides. No, that's
I
fine.
want
It's gonna come. Okay. So we did interviews with the practitioners, like Wolf and all from various corners of the system, including in some of these specific districts. Like we visited some high fast track and low fast track districts and talked with the police guys. And then what we got always as an answer was this kind of local law, right? There is substantial simple variation in what the local policeman or the local prosecutor thinks the law really is or should be, and they have the discretion. So one reason was bureaucratic. Simply, some guys, typically like the police chief or the district attorney, some were conservative, some were progressive in the sense of being willing to try new stuff, or just saying, oh, there's some stupid law coming from Prague, they don't tell us how to do things, right? So then we did hear that attitude, one way or the other. So there was a kind of the ideological preferences of these guys. There was a little bit of the organizational allocation. It's a little more difficult to explain that, like, historically, the districts vary in what they have. It's called detectives and the street units. And then these detectives, they also allocated different types of cases. So historically, it varied between districts, whether they do some, say, crimes of, say, thefts of medium severity. In some districts, it could be done by these detectives. Some could be done by the street patrol policemen, okay? And then when this came, these policemen, they liked the procedure more because it was simple for them. These detectives thought it's not real law. Okay, it's not a proper procedure. They wouldn't use it. So kind of the historical, allocation of staff and cases between these two types of guys would somehow determine whether they actually embraced it or not. Okay. More to that, like already this goes to, we might be worried about endogeneity, right? That there is some, say, political pressure to, say, be tough on petty crime. Well, and that, there was not such a case because these districts for the police and prosecutors and courts do not overlap with, like, the political districts in terms of the regional governors and the mayors. So there is no, like, obvious politician at the same level, geographical level, that could go to this district police chief to tell them, I want you to do this, okay? Because they simply very differently organized. And then, yeah, so that's it. That's what I have to say in terms of the institutional stuff. So what we do at the end is run, pretty standard IV to look at, when we look at these potentially eligible cases in the first stage, we predict the fast track status of a case as a function of the fast track share in the district at the level of that offense, right? So the fast track, we predict the fast track status of a theft by the fast track status in that district only among thefts. And then as a spillover effect, the fast track status of in all other offenses other than thefts, okay? And in the second stage, well, that's what we would like to do in that ideal experiment. Now the outcome, say the duration, is a function of this predicted fast track status. And and again, to estimate the spillover, the share of these fast-track offenses in a district. For the ineligible cases, we don't have to do any of this wizardry, and we simply look at, they only should be affected by the spillover effect. So we only look at this fast-track share in all other cases, say, other than sex crimes in the districts, and we estimate, the spillover effect.
So why you said it's a duration, right?
For example, or the outcomes such as charges or conviction.
Okay, that will change.
Yeah, that's different outcomes.
Okay.
We'll see a lot of tables. Okay. So the validity of the IV, how much time do I have? I don't want to go too much into the detail, but let's look at the main stuff. Well, so we need the randomness. So what's most important is that since we can, this is basically a diff and diff setup with an IV, right? So what we need is that this fast track is uncorrelated with the pre-reform trends or levels. Okay, and this is what it is. So here, this is the, here on the y-axis, you have the share of these fast track cases in the first year when the reform is adopted. Okay, that's kind of the first shock. Okay, and then here is the growth rate. There is the percentage change in either of these outcomes. For example, the duration during that 3 years preceding the reform. Okay, so for example, you'll be worried if say districts that go really, that are slowing down in their say their duration, they will be adopting more. It's not happening, and it's not there. It's not there in the other duration. Well, there's a little bit, but it's not. It's very weak statistically. We have formal regressions in the paper. It's not any significant predictor. We do that in levels. Again, there's simply nothing that's correlated. Okay, so these districts' characteristics before the reform do not predict how they adopted the fast track.
Sorry, one more question. Could you go back 1 second? So in the probability of churches, you have like what the number of reports. The ratio between sentences and the number of reports.
Oh, you're asking how exactly it's the variable is defined?
Yes, exactly.
Okay, so this is a well, at the individual level, it's a dummy whether the offender who was initially accused was actually charged at court, and then at the aggregate level, for each district, we simply look at the fraction of those that were actually charged. So say 85% of these accused would be charged, and then we see whether this increased or decreased over time.
Is related to the accused.
Yeah, it's relative to the accused. Okay. We have evidence that this is uncorrelated with the trends in observables. So again, it doesn't seem that the fast track share after the reform would be predicted by some trends in such as the case severity that's happening and so on. Okay, we do the monotonicity test. That is that when we kind of chop up these the first stage regression by various subcategories of crimes, we always get very similar relationship. And then, of course, for the instrument to be valid, it has to satisfy some decent first stage. So this is the first stage of the regression, right? Here is the outcome is the fast track status of a case, and the regression includes the fast track share among these eligible cases plus a bunch of other controls. Okay, and all kinds of these fixed effects. We conservatively include these district trends and so on. So it's this fast track share in a district is a very good predictor of a status of an individual case after partialing out all these effects. So we do have a very strong first stage. So it doesn't probably surprise. I mean, it's been kind of designed that way to be somewhat mechanical, right? But then these are pretty strong first stages. Okay. Okay, so that way we hopefully filter out any spurious error term that's causing an individual case to be tried by the fast track, and we look only at the overall intensity. What's important? Where do I have that? Okay, what's important is that the
Libor.
Yep.
Anna has a question.
Okay.
Yeah, Anna, go ahead.
Hello, Mr. Dusek. Thanks
Hello.
for your conference. And excuse me for my poor English. I'm a prosecutor. So
Okay.
I'd like to know, maybe you just said it and I didn't understand, I don't know. But Uruguay has changed its systems 3 years ago from adversarial.
Okay.
And we less than 90% of abbreviated trials. So the fast track.
Okay.
In your country, beautiful country, by the way, it was the same at first, at the beginning. You have many forms of fast ways to finalize the cases, and with the years, the cases increases to former trials and complete trials. I don't know if I'm clear enough.
So just to cut, so you maybe, Anna, you're asking about the pattern and the share of fast track procedures or the use of fast track relative to the traditional.
Yeah, I think it's this table, right?
Yeah, so that's it.
I think it is. Yeah, this is how many cases were actually, what fraction of cases was actually run by the fast track. And you can sort of see here the increase. Do you see the mouse actually?
Sorry, I didn't understand.
So here, right, it, for example, says that initially 20% in the first year, 20% of eligible cases went through the fast track. And then 6 years later, it was already 39%.
Okay, thank you.
And it varied hugely by crimes, like, for example, sex offenses, very few.
Or murders or something like that.
So that would not be eligible at all. So yeah, so these really have to be small crimes. Maximum sentence is 3 years. So anything more serious than that.
We have also a limit of condemn. I can find words. Just until there, and more than that, they are not eligible.
Yeah.
So
it's very similar, right?
Thanks.
Yeah. So I should say one more thing about the IV is that we're basically estimating the the local average treatment effect, which is a policy relevant parameter, right? Because it essentially tells you what is the outcome or the effect of that fast track on those cases that are on the margin between being decided for the fast track or for the conventional. Or that is, what would happen if, say, the prosecutors were deciding to prosecute few more cases, additional few more percent of cases through the fast track. So that's we think it's a policy relevant parameter. Now, here is a graphical, it's a picture that gives you an idea of what the outcomes look like, and also indicates some effects. Right? So here we look at the duration from offense to charges, and so you see we divide the districts into 3 groups, right? The blue are the high adoptions, medium and low. So based on how intensively they adopted the fast track at the end of this period, we divide them into 3 equally sized groups. And you can see that the duration was actually increasing by quite a lot during those years before. It stabilized with the reform, and then started declining, and it declined more in those districts which adopted most intensively. In eligible cases, there's still continuing upward trend, and it's difficult to say much. If anything, right, this gets worse in these high adoption districts. Probability of charges. Okay, so there's an overall jump across the board, and then again there is a divergence in which these districts with the lowest share do not grow much after the reform, but then there is a continuous growth in the among those districts that adopted most or at least medium wise. And again, not much action on these ineligible cases. This is the court duration. So one see that these districts were different, and there isn't really much of a divergence. Okay, and there is a convergence in the ineligible cases. And here is the court outcome, the conviction. So, and there is not, again, we don't quite see an obvious effect that these high adoption districts will be different from the others. But just gives you an idea of what numbers we're speaking about, right? Say the probability of charges, that's on the ballpark of 80 to 90%. And then the duration at court is around 200 days for these petty crimes, and it's about 1 year for the serious crimes. Conviction probability is on the ballpark of 85%. So here are the final, this is the final results. Okay, finally, get it? Okay, 50 minutes to get to the final, main result. So here are the estimates of the treatment of the causal effects for the duration at the prosecutor phase. So the direct effect on thefts is like 82 days. For driving offenses is 100 days. And then we can see a substantial direct effects on all these across all of these categories. Okay, it's pretty substantial, given that the average before the reform was, in the order of 200 days or something. Yeah. On the other hand, what we see, spillover effects, nothing significant. And if anything, it's actually positive, even though the spillover effects should also reduce the durations. And if we look at the ineligible cases, whether there is any spillover, again, it's not very precisely estimated, but also there's simply nothing negative, okay, at least nothing significant and negative. So this is going to be repeated throughout, right? We have strong direct effect, especially in this prosecutor phase. So one thing we're looking at, another result is the probability of charges. Again, we see some 8 to 10 percentage point increase on those eligible cases that were actually tried by the procedure. By the way, these two categories, there are some fast track cases, but not too many. For example, sex offenses, there's only like 6% of fast track cases, so nothing really happens here. Spillover effects, again, that's like not a strong evidence, a little bit here, not a consistent sign. Spillover effects on ineligible cases, again, nothing really significant. In the courtroom, we look at the court duration. So here the direct effects tend to have the expected sign, so reducing the court duration. Statistically, it's not significant. And again, the spillover effects, they definitely do not seem to reduce the court duration. And here is the probability of conviction. So again, there is a result, at least in some of these categories, theft and public order, we do detect a direct effect, an increase on the order of 5, 6, 7 percentage points. Something, but not significant in others, and something too negative and strangely negative in the sex offenses. Okay. And here we have actually something, here we have an unusual result for the spillover That is, this is consistently negative. It's not significant, but definitely it's consistent, and some sensible size effect sizes across all of these offense categories. So in a nutshell, we do have very strong direct effects on the prosecutor duration and the prosecutor charges, some weak evidence on the probability of conviction, essentially no effects on duration, or at least very small or weak effects on duration, and basically no spillover effects. And in anything, they tend to go, when they're insignificant, when they're kind of consistent, they appear to go in the wrong direction. So that's what we found. Now, we do have a battery of robustness checks. I will not click through those. We exclude the 10 districts of Prague. We check for another outlier. We estimate without the district trends, which gives us actually larger effects. So we present those conservative ones. We do another trick, which is instead of instrumenting with the share of fast track cases in that particular year, we look at the share only in 2002. Okay, the thought experiment being the initial adoption was a chaos that was really driven by some bureaucratic inertia or whatever, administrative preferences. But once that happened, the decisions to add or subtract was still taken by some kind of rational, or case characteristics. So let's just look at the very initial share in 2002 and as an instrument. And only interact that with the year dummies to allow for the fact that there may be a trend. So I'll show you the second stage already. This gives us a different instrument. It gives us somewhat weaker effects. One reason is also a much weaker instrument, right? Because it only uses 1 year to predict the fast track across the remaining years. But still, it kind of tells weaker, but still conceptually the same story of strong effect on this prosecutor duration. Again, pretty strong effect on these prosecutor charges. Okay. So now we're getting to the end. One question we ask is, what was the full effect of that procedure? Okay, so this is we do a counterfactual exercise in which we kind of see, hey, the duration say by the prosecutors has changed by this much over those 7 years. So, for example, it declined by 47 days among these eligible cases. How much of that can be attributed to the fast track, right? So we do a counterfactual exercise. For each case, we predict the duration or the outcome based on our regression coefficient and the actual values of all the variables, with one difference. We set the fast track to 0, right? So there is no direct effect, no spillover effect, but everything else, the case characteristics, they are the same. And importantly, the year dummies are the same. So whatever trend there was, we allow the trend to continue, okay? So that gives us that, say, in the absence of the fast track, the duration would have also declined, but only by 20 days. And fast track accounts, therefore, for the difference between the two. So of this 47 decline, fast track is responsible for 27 days. And the effect is clearly concentrated in these offense categories where it is actually being used, right? These very petty crimes, so the driving offenses. When we look at we do the same exercise with the probability of charges. Again, it went up on average by 11 percentage points. The model now tells us that it would have increased anyway, but only by 6 percentage points, and therefore the difference between these, the 5 percentage points, can be directly attributed to the fast track. And again, this is obviously concentrated in these, thefts and driving and public order offenses where the fast track is actually used. So last thing we ask is try to address a puzzle that we don't see the spillover effects. Even though, they were actually the objective, the the bill submitted to the parliament actually explicitly says that the objective is to release the resources of the policemen and prosecutors and judges to concentrate on the serious offenses. It didn't happen. Okay, so what's going on? Well, so our model can actually explain why we don't see that for the probability of conviction, because empirically more cases are tried and these cases tend to be the weaker ones. Okay. There was an offsetting effect. So I have another paper that looks what this reform has done in terms of crime. And the main finding is that this reform has hugely increased the enforcement of driving offenses, because it became so cheap for the policemen to process these cases that they started chasing the drunk drivers. And that created an additional workload for these enforcement authorities. And then the one we look at this paper, there may be possibly some inefficient allocation of cases. So as a matter of fact, we do not have random assignment, no way. Okay, so the prosecutor specialized and even the courts, Senate specialized. It's not individual judges like a typical district court would have, say, 12 judges, and they would be divided into units by 3 judges. Okay, and the cases would be assigned to these what we call senates. Okay, these panels essentially. And so they specialize in certain types of crimes. And now what happens with this reform? Those who specialize in the petty crimes, they don't need as much time to resolve their cases. So what is being done with that extra time? Okay? So it would be useful, at least we think it would be useful, that they increase specialization. Okay? That the guys who specialize in the serious cases give up all of their simple crimes to these guys, and they actually concentrate on the serious cases, right? Because I mean, it takes different skills and legal expertise to prosecute drunk drivers as opposed to financial crime or a robbery, right? And we gauge whether this happened. Yeah. So in the data, we actually do see individual prosecutors. We do see these court senates, not individual judges, but at least these subunits. We again divide them into the groups by their specialization, right? The specialization is what share of ineligible cases constitutes their workload, right? So there are guys who do only 4% of their ineligible cases, and those that we call they specialize, they do like 25 to 40% of their workload is these ineligible, more complicated crimes. And we look at their caseload and specialization by looking at what is the number of cases that they process, number of ineligible cases, and the share of ineligible cases. The idea being, if the response is to foster specialization, that we should see an increase in the share of ineligible cases among those who actually specialize in them. Yeah. So we measure that empirically, asking whether either the caseload or the specialization changes
Libor,
as a function. So
you have 10 minutes, right?
Sure, yeah, we're perfectly on track.
Right.
Whether these depend on the actual adoption of the fast track. So focus on column 2. There's a lot of numbers. Do focus here. Okay. What we estimate is, say, the share of ineligible cases handled by each individual prosecutor in a given year as a function of some time trend. And this is important, the fast track share and then the specialization. Okay, so the most important number is here, right? It says that the share of ineligible cases decreased most among the prosecutors who specialized in the ineligible cases, and it decreased most in those districts which actually did use the fast track a lot. Okay, so basically what seems to be happening is that these guys are actually passing some of their difficult cases to the other guys who don't have that much to do, okay, because they handle these, petty crimes, and therefore they now saved a lot of work. So the guys who do the difficult cases gave them some ineligible cases and took some petty crimes on themselves. Right? That seems that, there's definitely, these guys were not relieved. These guys who specialized were not relieved on these serious cases, for example. There's no reduction in the ineligible cases that they're actually handling. So it seems like they didn't use these opportunities to specialize in a way. It seems that what this indicates is some kind of equalization of the caseload, of the case types across these individual prosecutors. Yeah? And we see the similar thing here. Okay, if there is a lot of the fast track, then the panels that specialize actually see the greatest reduction in the ineligible cases rather than more specialization. So that's this is kind of exploratory, right? But we try to measure somehow what was going on. What did they do with that extra time? How do they allocate the caseload? And we tend to think this is not exactly, the best way to respond. So to sum up, first, what did we find in this paper? So we did find a very strong evidence of direct effects of introducing a simplified procedure on two outcomes, on the prosecutor's choice to charge, on the duration that the case spends with the prosecutor, and on the probability that the suspect is charged. And we see that almost across all offense categories. Rather, on the other hand, we find very weak evidence on court durations and probability of conviction at trial. We find basically no evidence of spillover effects. Yeah. So, of course, this is very Czech specific, but we build, the reform is kind of prototypical of many similar reforms across Europe. And I think it teaches a general lesson, right? So one thing is that simplifying the procedure can actually improve the efficiency of the criminal justice system. And it has broader implications, right? There's more offenders are being charged. There's no offsetting change in the probability of conviction, or it goes in the same direction. So definitely more accused people are ultimately convicted. So there's an overall increase, right? So these rules do have an effect on outcomes. So here more people actually are sentenced. We have nothing to say, admittedly, with the data that we have, whether that means more wrongful acquittals or more wrongful convictions or both at the same time. We cannot say. It indicates that there may be a trade-off between efficiency and justice. I think important theoretical contribution here is that we really do not find any of these spillover effects, which means these resource releasing hypothesis about plea bargaining, that releasing this workload on some cases miraculously, predictably increases the strengthens the outcomes on the serious cases. That was not happening, and the reason may be kind of in our particular context, lack of efficient specialization. So that's about it.
Okay, great. Thank you so much, Libor. I don't know if
questions.
Yes, please. Questions. Any question, guys?
Libor, thank you very much for your presentation.
Okay,
I think the first question that comes to my mind is that, your own empirical strategy relies on the heterogeneity of the share of fast-track cases at the district level that is chosen by whom? By the districts? How is that process? And how can we, assume that this process, that share is exogenous to the outcome variables you are measuring?
Yeah. So what we do is, so it's chosen initially by the police. So at the time of the arrest, he kind of sees whether the early evidence is if this is a simple case or not, and he starts prosecuting under that fast track procedure, and then the prosecutor has to either approve it or reject it. Okay, so there's a decision process, and usually the two guys simply talk to each other about it. Now you're right. There's really two dimensions to it, right? We perfectly admit that at the individual case, the choice is totally non-random. Okay, it really depends on evidence that we do not observe. What we do say is, we do hope it's sufficiently random. I know, and especially in the first years, is indeed the share. That is that in some district, even though, say the driving offenses, there's not really much of a heterogeneity, or simple thefts. There isn't really that much of a heterogeneity when you catch guys stealing in supermarkets and stuff like that. And yet, in some districts, especially this driving stuff, right? In some districts, they really chose only 1/3, and in other districts, like 85% of drunk drivers and or people driving without a license to be prosecuted differently. That has to do something with simply discretionary choices that cannot depend on the merits of the case. That's it.
More questions? I have a question related to Emiliano's. So basically, if we think about the probability of being caught and charged, which is one of your outcomes, right? And look at the share. So look at that table. You're showing the share of fast-track cases. If I understand, the share of fast-track cases could be considered a proxy of the resources available, and then one of the determinants of the probability of being caught and charged. So in other words, your instrument could affect directly the outcome in your second stage. Because if I have a higher share, then I will have more resources, or less or more share, I have less or more resources, and then I can affect the probability of catch someone and charge someone directly. Does it make sense?
I see. You mean that the instrument in part captures this spillover effect, right? There is a spillover, not only, say, what we're doing, right, in the specification is that we're doing a, say, on driving offense, we do a spillover from the fact that a lot of thefts are being charged. That's how we define the spillover. What you're suggesting is that there is a spillover on driving cases merely through the fact that more driving cases are being charged also.
For instance, yes, because basically, if I have more resources available or less resources available, that will affect the probability of catching someone and charging someone. So I'm not absolutely, I really like the paper, first of all. I really like the paper. For me in particular, it's very interesting because I'm working on this, but or something related to this. But I am a little bit puzzled about how you can sell me on the identification strategy. I mean, so the exogeneity part, in particular for that outcome variable, the probability of being caught and charged. For me, maybe I'm not getting it, and that's
no. I mean, you made a valid point. So didn't get that comment so far. Neither did we get that idea yet. So yeah, I mean, what you're saying, it is possibly a valid point that this overall share, say, among the driving offenses, right? The instrument is really, if on driving, it's a share of cases, of driving cases going through the fast track. It's not the whole share, right? So we kind of trying to insulate that spillover effect that comes from the overall. But it's true, if any of these offense categories constitutes a sufficiently large share of total cases, which is not quite the case, but however, and then if that spillover effect operates also within the category, then you would be right? And we need to, I guess we need to now think about whether we can kind of find a support that is kind of within group spillover isn't there, or somehow, yeah, I get the point. We need to address that, or kind of nail that down, separate that out somehow. Okay.
Great. Thank you for your answer. Any other question? Okay. So again, thank you so much. Libor, this is very interesting.
Welcome. It was a pleasure.
I think you have a really nice paper. Thank you for your time. Sorry for the inconvenience due to the new time. I mean,
It was a surprise.
probably, yeah. So, and thank you so much again. Thank you everybody for coming. And that's it.
Okay, thank you.
Take care.
Thank you very
Bye-bye.
much, Libor.
Okay.
Thank you.
Sure.